Okay, guys, I'm going to go into some stuff tonight, and I've decided to do this because of all of the lights, camera, action of the show. You know, sometimes I start to get into this stuff and we get distracted or whatever. So I'm gonna kind of, go over this from really the start. You know, where I actually said, you know what, enough is enough. I'm gonna send through certified mail a what's called a notice of reciprocal action. Reciprocal action meaning equal to, right? I'm taking that legal principle of res excipiendo fit actor, which is the defendant by plea or exception becomes plaintiff. I'm going to implement it right here and right now. And the date that I started this is right here, officially, November 17th, 2016. So I informed every one of these actors right here, okay, sent them a copy of this, and also informed these folks down here, also got carbon copied. That would be the Vice President, U.S. Attorney General, Governor of Ohio, Governor of Florida, Attorney General of Florida. Let's see here. The U.S. Senate Majority Leader, Congressman, Speaker of the House at the time, U.S. Senator for Florida, U.S. Senator for Florida, U.S. Congressman for Florida, and of course the Ohio judge at the time. And so nobody could say, oh, we didn't know this was coming. That's why it started. To all parties, persons subject to this case action. This is a lawful notification. Be advised, as of November 17, 2016, I have moved into a collections posture against all parties up to and including the government of the United States. This reciprocal action, or this reciprocal accelerated action, to pursue collections under the Keaton provision, Title 31, Chapter 32, Subchapter 3, Subsection 3730B-C. Tested under case Halper versus, under a Supreme Court case, U.S. versus Halper from 1989. Of my invoice, reasonable action, relief and remedy, due date, and all of these different things. So where this really started to become serious was the application is reasonable on the basis of intent to remove continuing threat. And in an 8-year battle, it was 8 years at that time. So kind of give you an idea. I've spent fighting against these parties of lies and deceits within this contemptuous legal monopoly, aka the bar, in its court of equity, controlled by that monopoly with equitable interest, to break its own rules. This action takes place under a continued premise of no confidence in the judiciary and breach of trust to act per its established mandate to interpret the Constitution or to interpret constitutional law without bias or other interest. Seemed pretty clear and pretty concise to me. I have contracted access collections out of Tampa, blah, blah, blah. And I informed them at this time, it was just outraged and disgusted. I hadn't even gotten pissed yet because I hadn't actually created my company. I was just saying, hey, I'm just a dad here to bust your chops. So get ready because this is going to get ugly. So as I proceeded down through the process, I've shown you kids the reports. You know the reports. Maybe we'll go over them at the end here, but gone through it, tested 3 cases, and here was the conclusions that the bar, the Democrats, and the political entities had weaponized the family court. This was a supplement, meaning in addition to, based on this, at the time, this executive order on human trafficking and serious human rights violations. So this is where it kind of said, okay, I I had already created E-clause by this time. I informed them, now there's that first legal principle, the defendant by plea or exception becomes plaintiff. And of course, the regular, the rest of these. Created company email, the whole bit, company letterhead. This lawful notification came later. This was post the parliamentary inquiry in the Supreme Court decision, where I'd informed the White House, but this is what lawful notification letter looks like, so you kids know this. This one, another lawful notification as of November 2018. This went to the clerk of the United States Supreme Court. This was right after Brett Kavanaugh's confirmation hearings. What had happened between those two times was now, as of, a matter of fact, it was Stephen's birthday, we had a standing mandate where the court said, you know what, Dad's got a point. Government is a piece of paper. It can't have an interest or it can't have a standing. That's a political flawed argument. So they said, okay, if you're going to stand in a courtroom, it's going to be you versus them, not them versus you. So, of course, I informed the Supreme Court through this lawful notification of process. In other words, I'm not asking them, I'm telling them this is what we're doing. And should the justices wish to enter an opinion on this matter, I would welcome any insights from their perspective moving forward. Nothing disparaging or I would call contemptuous in any way against the judiciary. I said, I'm here to ask you. I'm here to inform you of this judicial mandate. And right here, and you want to enter an opinion, enter an opinion. I don't have any problem with that because we didn't have the Supreme Court's order yet from the state of Florida. All we had was a standing mandate. So here was when I informed them of that, and this actually went out in the mail. Let's see if I can zoom in on that a little bit. Get a date that this bad rascal went in. 11/20 of 2018, right up here at the top of the receipt, 2:28 p.m. Here was the tracking number. You can track that with that rascal if you would like. Anyway, moving on. What was behind that, or what was under this cover letter, was this Supreme Court brief, which is actually the same thing as basically the remonstrance, for lack of a better expression, just with the Supreme Court's cover page on it. Where I was citing the unauthorized or unlawful emoluments as unauthorized practices of law. Sharia law is not law in this republic. Practice and enforce that is treason. It is what it is, and I'm going to get into that in a minute. But pursuant to Florida statutes, that's the Florida statute, the applicable public law that applies to them. And this is me informing them that I'm going to stand my ground against this. Totally lawful. Against things like malicious prosecutions, false arrest and imprisonments, a couple of declared acts of tyranny, conduct of tyrants, basically. And I had just informed them, because of the emoluments of my office, I'm informing them that this is an amicus curiae, basically. You know, again, you want to enter an opinion? Enter an opinion. I don't have any objection. I know you have discretionary jurisdiction. It's going to come up at some point in time. I know it. You know it. I know it. You know I know it. Whatever. Here is the mandate of which I was speaking. In the case style, the court mandated that it's me versus the department on behalf of your mother, not the other way around. So what does that do to their relationship? That means they can't act on behalf of your mother because your mother's not a resident of the state of Florida. Can't have a fiduciary duty. That means the contract is not lawful. That is an improper use of the Commerce Clause, the second jurisdiction. Remember, in our republic, there are only two. Out on the land is the law of contracts, the Commerce Clause. That's the law between the states. The law of defense, the first jurisdiction, is that 10 square miles of Washington, D.C. That's the reason that there are two jurisdictions. Now, the Constitution is the first jurisdiction, right? The defense of the nation. That's why we put Washington, D.C. where we put it. So, obviously, to defend against crap like Sharia law, which is another reason why our republic is only 3 pillars of law, not 4, not 5. So, this came later on, this filing, the Supreme Court order, this came on March 14th, 2019 at 2:17 in the afternoon, where the Supreme Court basically said, hey, we don't have jurisdiction for this until the appellate court issues an opinion. We have a standing mandate, we don't have an opinion. So issue an opinion. So don't come back to us, or don't do anything else till the appellate court issues an opinion. That's basically what all of this says right here. So you're more than welcome to go read those cases, do whatever you like to do. But zoom back out of this a little bit. There we are. So in the meantime, what was I doing? I said, okay, well, that notice of reciprocal action, I had to inform them that, okay, we're going to play Monopoly Corporation. That's what we're going to play here. So here's my corporation, and there is my business license right there. There's my number. So want to know what it is E-clause is actually doing? It's in this paragraph right here. This was the intended purpose of this company. So the other thing, when you're talking about law, or you're talking about any form of law, that's indicative of a research project. Well, what are we researching and developing? This body of law known as the Emoluments Clause. Okay, well, I have a fiduciary duty, a license in commerce. So they want to play license. I got one of those. Let's play license. Okay, here's mine. Want to verify that? Go ahead and verify that. The number is right there. Go verify that. You can verify that with the state of Ohio all day long. It's in the microfiche section. Now, anybody who knows anything about a contract knows that there are elements expected of a fiduciary, one of which is performance. Concept dating back to the 16th century. And that definition coming from the Black's Law Dictionary, 10th edition, which is where most of these definitions came from. The successful completion of a contractual duty. Oh, there it is. There's that word, a duty. Usually resulting in the performance or performer's release from any past or future liability. In other words, this person here, the fiduciary, right, did what he or she was supposed to do pursuant to the terms and conditions of the contract. Okay? Seems pretty simplistic to me. Also meaning that because nature abhors a vacuum, I can also credentialed, under that credential, qualified to call out defective performance. This one, right here. Okay? You know, no, I recognize shit made up when I see it. So this one is a performance that, whether partial or in full, does not fully comply with the contract. And that was where I focused because, again, having paid this person, I won't mention any names just quite yet, having a specific advantage emolument. And how do I know what an emolument is? Oh, let's see. Well, let's see. Let's look at my oath of office, because I have one of those. Oh, there's that word right there. Okay, so I have one of those in my oath of office. Well, knowing that there is a duty, we just discussed where the duty comes from, that's under performance. So my assessment of being in a position of emolument implies a duty to perform whatever terms, conditions, of the contract are. So when you walk into a courtroom and your bar member sits there like a friggin' bump on a log and won't even say, yeah, objection, somebody's is attempting to enter facts that are not in evidence. Okay, so let's see here. Let's go into what the duties of a notary are. I think that's pretty important. Well, before we get to that, the first thing is to know what it is. Notary or notary public. An officer appointed by the executive. Oh, that's the executive branch. Pillar number 2 in our republic. Or other appointing power, meaning could be Congress, under the laws of different states. Okay, that's pretty straightforward to the point. Now, here we go again. Their duties. There's that word again, duties. That means there's more than one. Okay, well, they are generally prescribed by laws. The most usual of which are, number 1, to attest deeds, meaning confirm them, agreements and other instruments, okay? In other words, ensure the truth in the record, confirm those things, validate those things, right? In order to give them authenticity. That sounds like a pretty big responsibility, a pretty big duty, right? That carries with it a certain level of responsibility, I would think. To protest notes, bills of exchange, and the like. Protest. Well, if I have to protest something, in other words, if I see something that looks like potentially what? SMU? Shit made up? That means I also have a duty to do that. That sounds a lot like mandatory reporting to me. Okay. Well, then in number 3 here, it also says to certify copies of agreements and other instruments. That could be anything from a contract to a transaction to verifying the person signing the document is in fact the person signing the document. Okay, so in the tools of my toolbox, I don't want to go into all this history. We can do that again at another time. That was just more specifically trying to focus on that word and what Dad's job was, is as a notary. So there's a duty in there. That means there's an expectation of performance in there, at least to somebody to whom I'm using that credential to perform a service for. Seems pretty simple so far, right? Pretty basic stuff, right? Well, according to the bar, not so much. So let's go into what are some of the tools in my toolbox. Well, this form here is what's referred to as a short form of individual acknowledgement. So in other words, if somebody brings forth a document under subpoena or complies with a request of any kind, one of the tools in my toolbox as a notary is to fill out this acknowledgement form and correctly acknowledge the title or type of the document, the document's date, number of pages, and the signature other than the named above. In other words, who brought who requested the document. Okay, so maybe this might be somebody as maybe a witness to the transaction, right? So again, somebody else to attest to confirm what's in, what we are stipulating or what we are acknowledging. Okay, so that's one of the tools in my toolbox. Another one is a jurat form. This form has multiple different purposes. Again, fill this little rascal out. State of, county of, and then of course, same thing here. Description of the attached document, type or title or type of document, document date, number of pages, signers other than those named above. So, and then who would be the signer? Person swearing or affirming, and then there's where my signature goes right here. Okay, name of that would be my name printed or stamped. I have either way. I have to cite. Do I know this person, or do I know this person? Personally know them, or did they produce some form of identification, and then what that is? So, again, these are duties to perform under the terms and conditions of the emoluments of this office right here. So I think it's safe to say that I have a fair grasp of what practice is, right? So the difference between the theory and the practice, it's safe to say that between this credential and this credential, I think it's safe to say the old man's pretty good at doing business, been doing it for a while. So moving on past these documents here, I'm going to go in here and let's see, I was going to use a couple of, okay, performance. Talk a little bit about the Constitution. Just amendments in question. First one, the 7th one, the 9th one, the 11th one. And yes, even though I have, known for a while that this one was technically speaking not properly ratified, and there's evidence of that, but we won't go into that right now. But here's another principle of law. Because I have an emolument, as I've just explained, I would literally be in, as long as I'm in the performance of those duties, and as long as I know a thing, to know a thing and to be bound to know it are regarded in law as equivalent. So in other words, as a person in position of emolument, in my official capacity, it's pretty much safe to say I'm bound to know this stuff at the bare minimum, right? Just use a couple of amendments of it as an example. So you see what I'm saying? This is why the education behind the law, the science behind the law is so important. So if you're going to take on a position of service, you better know what you're doing. And in the private sector, when we do particular jobs with government, these are things are known as, those payments are known as subsidies. Okay, so it could be research and development grants, it could be payment for services rendered, products sold, anything from a pair of brake pads to a battleship and anything in between, depending on what it is you're selling the government and people of the United States. Again, zoom out on this just a little bit. There we are. Make that a little easier. So, as we manage these big companies, big corporations Dad used to work for, a job being loss prevention, and of course managing stores and doing other things that I've done. There are 10 basic principles, things you kind of really need to know, just sort of right. I call them the rules of thumb, because, if you're going to be working within a large group of people, then it's kind of good to set up some basic principles, okay? Especially when you're making decisions. First one of those, if you're going to assemble as a group, you must have the authority to take the action you're purporting to take. In other words, if we're going to say, I'm making a decision, or we're going to make a decision in the company, that decision applies to the company, okay? And the people that work within the company, as long as they're on the clock in their official capacity. Once they clock out and go home, as far as they're concerned, it's all shit made up. Well, half of them would say it's shit made up anyway, but I digress. Then, of course, we go down through the principles of, oh, yeah, got to have meetings on this stuff. I used to joke about it all the time. Well, we're going to have a meeting to discuss the meeting, which we're going to have another meeting of, which is going to follow that meeting. You get the idea. Proper notice of the meeting must be given to all members of the group. So in other words, you can't hold a meeting without giving them proper notice. Seems to make sense, doesn't it? Must be a quorum present at the meeting. We'll cover that in just a second. There must be a question before the group upon which it can it can make a decision. In other words, you don't just call a meeting to just sit there and stare at the wall, right? There must be an opportunity to debate the question, if there is such a question. The question must be decided by taking a vote. There must be a majority vote to take an action or decide a question, right? So a majority would rule in this particular instance. There must be no fraud, trickery, deception resulting in injury to another member. I would think that because that's literally the 9th commandment from the Bible, that one would seem pretty rudimentary to me, but apparently today, not so much. So takes us to number 10. To be valid, any action or decision of a body must not violate any applicable law or constitutional provision. Well, what did I just get done saying here? Just a minute ago, just part of it. To know a thing and to be bound to know it are regarded in law as equivalent. Okay, well then if I'm going to swear an oath of office to perform the duties under this emolument, you see where I'm going with this? That means I'm pretty much bound to know this stuff. Can't do my job if I don't know this stuff. So that would require study. That would require education. So let's expand on those principles just a little bit, because I think this is going to make life easier on you guys as we do this. These come from the Mason's Manual of Procedure, by the way, 2010 edition. I based this on the premise that the law speaks to all with one mouth, right? One standard of justice. Jurisdiction must be given. It cannot be assumed. Groups sometimes assume powers they do not have. Imagine that. Wonder where we've heard that before. When authority is vested in the group collectively and not merely in the individual members of the group, to make a decision, the group must make up its collective mind. Okay. In other words, what would you do at this meeting? Well, first of all, somebody's going to say, well, you have authority there. Maybe this would be a good time to look at the law, look at the Constitution, and say, do we really have authority to do this? Based on the subject matter. And you make the decision whether to proceed or not. So, which I always thought number 3 should have been before number 2, but I digress, because how can you have a meeting without notice of meeting? But anyway, so we're going to get into the quorum. What is a quorum? This comes from the parliamentary law. Oh, that would be this book. Cool. The smallest number of people who must be present at a meeting must be present at a meeting so that the official decisions can be made. Specifically, the minimum number of members, a majority of all the members, unless otherwise specified in the governing documents. So in other words, this right here would be a place where you could say, well, we have 100 members in our body, and the 100 members have confidence in, say, 20 members. To say, you 20 members are pretty knowledgeable on this stuff. Why don't you get together, have a meeting, figure it out, bring a report back to us, and then we'll make the decision, right? It's a pretty good way to do business, because 20 people can go handle that. 20 other people can go handle something else, and you can kind of do things. You can get a lot more done that way with those 100 people if you divide up the task, which of course is how we do things in the private sector all the time. So, let's see, who must be present for a deliberative body assembly to legally transact business? So, And the plural form is, to put an S on it, quorums. So if you want to verify that, you go to Black's Law 10th edition, page 1446. So, number 5. Oh, here we go. There must be a question before the group upon which it can make a decision. Okay, well, now that you've verified authority, okay, the question may be a motion, resolution, or other proper form. May be oral or in writing, and in most cases should be capable of being answered by an affirmative or a negative vote. Okay, so chances are if it's something that's outside of the purview of that, it's going to require some extensive study, research and development, kind of like what? The Emoluments Clause. A member has the right to know what the question is and what its effect will be before voting on the question. What did I just say about you have the meeting, you get those 20 members together, they hold the original meeting, assess what it's all about, and to decide what, if any, what its effect will be. You know, what effect or affect is it going to have by even making this decision? Okay, there's a process for that. It's actually one of the 10 principles. So let's see here. There must be an opportunity to debate the question. That's pretty standard stuff. This is just basically the same thing there. I'm going to go right down here to number 9, because this is where it starts to get really, really, really important. When it comes to fraud, trickery, or deception resulting in injury to another member, the expanded version of that is a person, an individual, is entitled to protection of the courts from injury through injustice by a body making a group decision, as in any other situation involving injury. Now, what would one example of that be? Well, let's see. Let's go back to the first principle. The group must have the authority to take the action it purports to take. Okay? So even if somebody comes and says, oh, I'm going to give authority to this group. Okay, well, you're going to give authority to that group. Does that necessarily qualify that there is a jurisdiction? Okay. In other words, yeah, we need to assemble the quorum, okay, to decide, again, do we have that authority? And this is where many of these things fail in the courts, because upon a review, when you can figure out that there was some form of fraud, trickery, or deception that, you know, that played a role in any part of the process, the entire thing fails. This is one of the reasons why I cite, where did the wheels come off of the wagon? Right? That would be, where's the fraud? Where's the trickery? Where's the deception? Where the wheels came off the wagon is the trespass. So everything else that comes after that is victimization. So, to be valid, any action of this or decision of the body must not violate any applicable law or constitutional provision. Decision-making procedures of any body must comply with the applicable provisions of any local, state, or federal law. Period. In other words, the operating box is actually pretty small, right? There's how are they taking actions on things that are literally guaranteed, that are ours to begin with? They don't have standing in law to do that. And this is the reason we have the courts that say things like, hey, can I, if they walk in with a question like, hey, can I claim good faith if the action I'm taking, that I know this action I took violates state or federal law? No, that would be Owen versus City of Independence. So if we were going to test that theory, this ninth principle, I would cite Owen versus City of Independence from, I think it was 80 or 83, would be the test of this principle. Okay. And of course, Hardwick versus Vreeken from 2017, reaffirming that. It is governed by any statutory or court-made law. Now, see, this is where I have a problem, because court technically doesn't have the power to make law. It has the standing to decide decisions and findings of facts, conclusions of law that are before that court at the time. But to say that it's court-made law, I think that's a stretch, including provisions of constitutions and charters. So, why would you say constitutions plural? Constitutions, because we're 50 states. So between the law of the land, the first constitution, and the 50 subsequent constitutions, I count 51. So, and of course, as we do business in corporations, that corporations are set forth under charters. I just showed you mine. Let me go back through that again. My corporate charter was, this bad rascal, right? Yeah, that would be an example of a corporate charter. So, kind of give you an idea of why those things are equal, or partially equal anyway. Whoops. What happened to my, here we are. So, let me go back down here. So now that we've decided what the principles are, what are the basics, right? What's the, what are we going to do with this bad rascal now that we've decided that we've come through all 10 principles pretty much unscathed, or not, or if you find something that is wrong, and you need to bring that before the body. Well, look, Congress, I know what these persons told you, right? And this is why they wanted to be able to have the authority to contract, right? Well, when the court decides that a particular thing, call it whatever you want, has failed, that means you can't contract in it anymore. I cannot do in my person, I cannot do through the agency of another. Agency being a contract. So we call them into assembly, right? And that is section 795 from right there, page 561, right there. And this is the process by which we do that. This is where that power to peacefully assemble them comes from. And there is no requirement per se, right, that says, well, you have to do this, this, and this before you can call your legislature into assembly. Let me show you how I know that. So, let's see here. We're going to go down into, let's see, was that Quorum, public officers. Somehow my thing got screwed up here. Where did that page go? You have to pull that up through a different item here. So, all right, I can certainly do that. Can you just bear with me just a second here? And so we decide, okay, well, why does the legislature have authority to convene and provide oversight? Well, again, government is always accountable to the people. And we look in here at this principle number 10, an investigation into the management of the various institutions of the state and the departments of the state government is at all times a legitimate function of the legislature. Okay? It doesn't say, well, except when there's blah, 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 blah. No, that at all times means at all times, right? So if you have an agency taking an action that is outside of the scope and authority of that agency, practicing a law that is not Republican in character and form. We'll get to that in just a second. Pull this back up again here. So let's go into what is a republic. Well, 3 pillars of law. Those are here at the corners, not the centerpiece, by the way. That's just, if you were going to stand that up, it would look like a 3-sided pyramid. First, number 1 is the legislative. Pillar number 2 is the executive. Pillar number 3 is the judicial. So now that we have built this government, one of the articles that we use to govern it, to keep it in this character and form, okay? Terms, conditions of the contract. When we swear these actors into an oath of office, well, again, to know a thing and to be bound to know it are regarded in law as equivalent. So, the United States shall guarantee every state in this union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive against domestic violence. Okay, when the legislature cannot be convened, basically, is when they, go to the legislature first, because that's pillar number 1. You go to the executive second, because that's pillar number 2. So again, order of operations, mathematics 101. And so let's talk about this right here. These 2 words in context: domestic violence. And I'm gonna pause right there real quick. Okay, get back to where we were here. Now, under the context of domestic violence, what is that? What does it mean? Well, this is where we start getting into the beginnings of the conflict, because if you actually read the true intention of the Constitution, domestic violence, remember at the time, there was no infrastructure. Hell, there were even few homes built at that time. So one of the things that they had just left was tyranny. So the implication of being domestic, meaning out on the land, okay, not within your home, right? So in other words, that would be an attempt to overthrow the government, overthrow the people, right? Overthrow the law. Okay, that would be a form of domestic violence, or insurrection is what you're going to probably be hearing it called before too long. Another confirmation of that assertion is we look at my corporate mission statement, which happens to be the preamble to the Constitution. Well, it refers to domestic tranquility. That also meaning out on the land, domestic, right? Tranquility meaning, life, liberty, pursuit of happiness, right? Definitely no violence of any kind, that kind of thing, right? Because when we go back through and we look at the Declaration of Independence, let's pull up a couple of those declared acts of tyranny that I like to talk about. Another example of, here it is, there it is right there, domestic. There, see that word keeps popping back up. He has excited domestic insurrections amongst us and has endeavored to bring on the inhabitants of our frontiers, the merciless Indian savages whose known rule of warfare is undistinguished destruction of all ages, sexes, and conditions. Now, what does that mean? They're trying to manipulate the people, some people, into warfare, committing acts of warfare that are undistinguished destruction of all ages, sexes, and conditions. Now, that's declared conduct of tyrants when you're talking about domestic versus, and whether that is domestic tranquility, which is in the context here, or we go back to, Go back to, all right, what did I do here? I'm going to do that. All right. For some reason, this thing is slowing way down. So, we go back to, now that we've pretty much gotten an idea of what domestic violence is, being insurrection, I want to know, and let's talk about one last thing here. As far as the pillars of law, the branches that would have any jurisdiction over domestic violence, that would be, the first one is the legislature, the other one is the executive. I don't even see the word judicial even anywhere near here. So there would be, that would tell me there's no jurisdiction, right? So, moving on. If that's the case, explain to me who has made the allegation that me with my children have committed acts of domestic violence, meaning to overthrow the government. That is an odious claim. That is shit made up. Sorry to be a little bold and blunt about it, but there it is right there. That would be a false claim. So, when we go into this new act right there, based on somebody in a position of emolument. Get back to that in just a second. So, now that we've discovered that the word judicial or judiciary doesn't even appear in Article 4, Section 4, where domestic violence is discussed. Don't even see it there. How do you have that case number? That would be an odious claim. Because if you were attempt to overthrow your government, that would be treason. So, again, you stepped on the Lego. Leaving your Legos around there, Stephen? Hate it when you do that. Told you about that. Anyway, I digress. Let's see. So, what is a republic? It's a good question. A government having a chief of state who is not a monarch, meaning a king, right? Who is not a monarch and is usually a president. Also, a nation or other political unit having such a government. That would be our county government, consisting of 3 equal branches. A government, excuse me, in which supreme power is held by the citizens entitled to vote and is exercised by elected officers and representatives governing according to law. In other words, what we stipulate to in the terms and conditions of the contract. So if we don't agree on it, we want to challenge it, we can take it up to these guys and issue the challenge. Or we can go in here and go, dude, the court has said how many times that you can't do this. Or you can walk into here and say, dude, the court has said how many times you can't do this, whatever the this is. So that is the, go back to the First Amendment. Let's look at that First Amendment real fast. Oops. Back up out of here. Here we are. Whoops. Okay. What does that First Amendment say? Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Okay. Or abridging the freedom of speech or of the press or the right of the people to peaceably assemble and to petition the government for a redress of grievances. Okay, so in the true context of the Republic, well, your petition begins, you start at step one. That's the legislature. To me, that's pretty much common sense. God forbid we would have common sense. Now, mind you, that's only 3 pillars. I don't see that 4th pillar of the bar. Right? That 4th pillar, that monarchy, that stare decisis, that shit made up. In American jurisprudence, that would be something to the effect of the enumeration of the Constitution of certain rights shall not be construed basically in any court or anywhere else to deny or disparage others retained by the people. Well, the bar says, or should I say, the judiciary, the Bar Association, as far as I'm concerned, the way the character and form of the judiciary has taken on the character and form of a monarch. And it's stating that, well, this amendment is, they call it an ink blot. If you go back and watch the Kavanaugh hearings, he stated he thinks that the academia calls this an ink blot. I would call the fact that he would even say that a disparagement, right? He cannot deny or disparage when he's in an official position of emolument. Can't even make that claim. That would be an odious claim. If 56 men who built the Declaration of Independence felt it necessary to include this sentence and call it an amendment, there's a reason for that. Okay, this is not shit made up. This is real right here. So now that we're learning the difference between what's real and what isn't, the fact that one of the justices that sits on the Supreme Court refers to the 9th Amendment as an ink blot, I'm a little upset about that, no matter whether I feel sorry for the man for getting beat up by Democrats or not. I have an issue with that. And of course, we know these actors, they hide behind the 11th Amendment. Well, again, there have been many cases. This is the particular one here that I've cited, and the short version is the 11th Amendment does not protect state officials from claims for prospective relief when it is alleged that state officials acted in violation of federal law. Well, okay, first jurisdiction, federal law. Personally, I think anybody who would disparage this language, that's a double negative. As far as I'm concerned, that is that makes that an odious claim, shit made up. Because that's the one thing you're not supposed to do. Shall not be construed. Period. That doesn't say you should, doesn't say you could, doesn't say you might, it says shall. It basically means you will not construe to deny or disparage others retained by the people, meaning those others, meaning rights. So now we go back to you can tell I'm a little bit passionate about this. I've been doing this for a while. They want to know what a quorum is. Tell them to turn to page 331 and look at section 500. Okay, that is part 5 on quorum, voting, elections, and under chapter 44 in quorums. So if anybody wants to know what a quorum is in the deliberative body, tell them to go pick up your book and begin here. A quorum of a deliberative body, whether legislative body, administrative board, or a court, must be present in order to transact business and to make its acts valid. So if you go into one of these Article 1, quote unquote, Star Chamber courts and you cite there's an absence of a quorum, that means that group, body, person, individual, whatever, cannot transact business lawfully because there are not enough members for that act to be valid. Any action that takes place in that particular forum, judicial forum, as is technically speaking, is not valid. Because if they're claiming their Article 1 courts, well, Article 1 being Congress, that would require a quorum or a form of a jury, right? Because in essence, a quorum is a form of a jury. Because you've got a group of people making a collective decision. So you could state, well, jury nullification, for example. So again, don't ask me, wait a minute, yeah, it's 331, 332, 333. We can go down through this and bore the crap out of you. Or we can just go into this parliamentary inquiry. So this is where it starts to get really, really interesting. Now, what is a parliamentary inquiry as far as due process is concerned? Hey, I have a question about this word in the emolument, in my oath of office, that word right there. I want to know what that word is beyond its dictionary definition. So, what would be a good way of stating that? The way I did it in my notice of appearance was I put a maxim of law, right, in the language of the court, expecting a court challenge. So it would have to be, if I want to know what this thing is beyond its dictionary definition, I was looking for an answer that stated something that implies a duty. But he said it's a stipend, so I went with the business plan, which I'll show you in a minute. So in order to rightly comprehend a thing, it is necessary first to inquire into the names, for a right knowledge of things depends on their names. Okay? So, in the context of doing business in a business plan, in this case, government business, okay, my question before the body, basically impeaching Title IV, was to begin with this word. We're gonna research and redevelop this word because it's pretty old and it's not very well used in the context of court decisions. And I have an issue with that. Because if there's a duty and you're not citing what the duty is, that would be a defect in the practice. So, because as far as I'm concerned, as you can tell, I work pretty hard to put these things together to where you can look at this thing, get a pretty decent idea, at least the judges sure as hell do, of what this thing is, what it says, what its intended purpose is, right? Including where it is, right? What law, what process, whatever are we talking about? What is the implication? Well, this is a follow-up in the matter of, right there. Okay? Well, the judicial mandate in standing at this time is me versus these guys, not the other way around, the way they're purporting it. So that would be an odious claim for them to continue doing that the way they're doing it, right? That would be a falsehood, fake news, right? So you see how this works. I can bring forth before the body that which I know, right? And being that is mandated by Judge J. Cohen, again, I always thank Judge Cohen for, performing that mandate, because he knows my goal, what my goal is to get rid of these emoluments that don't exist in our form of government, right? And referenced in Annals of America as emoluments of statutable plunder, and I'll get to that in just a few minutes. Oh, no, I won't. I'll get to it right now. So let's get to what we've learned about the Emoluments Clause at this point in time. I said, okay, well, based on what we already know, okay, And what emoluments are is a stipend attached to some office. I basically said, look, Madam Chair, Dianne Feinstein, this woman right here, right? She might be a Democrat, but she's the one who executed my parliamentary inquiry, so I believe I owe her due respect. I brought before her a motion to set aside indefinitely. That's what it is. That's what a Mason's motion number 3 is, DIRT's 23 is. In this matter, right here, right? Pretty simple. And here's the substance of this, and of course I sent a copy of this to the president. I said, I'm going to accept that fiduciary duty. That means I got to at least perform that fiduciary duty under the law. Part of that duty is notification correctly. So this is where I literally asked her, cited the political question doctrine, right? I just said, here, you can verify that right there, right? No harm, no foul. Saying, look, I'm just here, come before you in the form of this motion, not as a party member, but instead as one of the people, pursuant to this doctrine right here. You can verify that, which I'm sure she did. And referencing the Emoluments Clause matter, right, page 638, pursuant to the definition on, pursuant to the 1991 definition on page 638 of the Black's Law 10th edition. I said, look, we know what you're trying to do. So I'm going to ask you a couple of questions here, just before you guys go think about this. Look around the emoluments of your office a little bit. One word really worth going to civil war over after more than 230 years of peaceful history under our belts. And add insult to injury, are emoluments of statutable plunder the legacy for which I am to be remembered? If you want to verify that, go to Annals of America, Volume 2. Don't take my word for it. Go verify it. Seemed pretty simple to me. And in context, I sent just a general motion to Jerry Nadler, who is saying, hey, look, I've already handled this issue with Dianne Feinstein, so we're going to talk emoluments. Let's talk about them and what their true context is. Okay, you're the chairman of the House Judiciary Committee. Okay, well, I have an issue of this. Here it is. Okay, so come before you in the form of this motion in my official capacity as loss prevention counsel in this matter, citing the attached Florida Supreme Court decision for this matter, pursuant to the violations defined in the Hobbs Act, revised 10 of 2012, as related to the events of May 1, 2018. Remember, what's before the body? Well, I can only bring forth, in my case, in this matter, is what has happened, things that they can go verify in this matter of, right? So we now have to address matters of relief and remedy as outlined in the parliamentary inquiry remittance page filed by this office and received and executed by Dianne Feinstein under Bill Barr's confirmation hearing process hearings. Again, whether you were there, Jerry, or whether you weren't, have taken the liberty of decoding these emoluments of statutable plunder as outlined in the text referenced in the petition, Annals of America, Volume 2. And I also informed him that 2 other houses of Congress, Ohio and Florida, did get a copy of this motion. So when it references violations under the Hobbs Act, being in the Commerce Clause, because that's where they're operating, this is the body of law, right? When we talk about interstate and foreign commerce, okay, so there's the stipulations. I also sent here on May 30th this motion to the Senate Judiciary Committee. And this is where Senator Graham and Senator Feinstein came together. This one is very, very simple. Loss prevention comes before you in the form of this motion in my official capacity as corporate counsel in this matter, citing the attached Florida Supreme Court decision for this matter. Please find the attached writs and other information related to this matter in spite of what the Florida Supreme Court ruled in this case, in that Sharia law is not Republican in character or form. As a Republican, I think he would take notice of that, and he has. Knowing and understanding the complexities of political arguments and processes as well as I do, I hope you find the attached proposed legislation, this thing right here, the Shit Made Up Act. Let's see if I find proposed legislation to be compliant with the intent or intended purpose of the original 13th Amendment, and enjoy the intended humor I have also supplied to assist you in actually writing the language of this act properly. So in other words, I'm going to have a little fun with you, to kind of help you unwind a little bit, and we can go back to work. So I've taken the liberty of decoding these emoluments of statutable plunder as outlined in the text referenced in the petition, Annals of America, Volume 2, and Title 4 et al. Diagram on page 2 of the writ of supervisory control. Obviously, you got a copy of that. So, also again, 2 houses of Congress in addition to United States Congress, performing my fiduciary duty under the law. And what did Bill Barr say about in that parliamentary inquiry about that word in emolument? That is a stipend attached to some office. Well, then, in that definition, that would fit right between this title and these offices, specifically that one right there. So now we have definitive proof and acknowledgement through congressional inquiry that entitlements are actually emoluments. That's what they are. Okay, so now that we know that, so let's talk about where the political argument comes in. Let's go back to that domestic violence, that political argument. Remember, we said the word judiciary ain't even there, right? That shit made up. That's what I mean when I say fake jurisdiction is the baseline being forced. Shit made up. Let's look at that. Pull that bad rad rascal back up again, And here we go. This is a fake jurisdiction, fake case, shit made up, fake news, as President Trump calls it, fake news. So how can there be a judicial action based on law that was intended for Article 1, the legislature, and Article 2, the executive branches of government? I said, now, because this is 5 pillars of law, this nexus between this, stemming from this 4th pillar, okay, well, why is this a nexus? Because, again, you have the 4th pillar of the bar, the 5th pillar of this Sharia law, okay? There's the pillars right there, and right there. And that is a jurisdiction foreign to our form of government and unacknowledged by our laws. Because domestic violence is not a judicial argument. It is a political argument. So, this is why you're going to notice that when reference to what's going on the southern border right now is the actual constitutional interpretation of domestic violence. We're being invaded, right? So Now, in the actual remonstrance petition, I wrote one up. Looks very, very similar to the one that just got dropped on their table, but this is the general gist of it. Again, we've had this conversation on weaponized family courts, so here we go. I'm here to update you. The last time I was here, I had a judicial mandate in standing. Okay? Through this guy. Well, since then, we've had a Florida Supreme Court decision by the Honorable Robert Hodges. So, again, thank you, Judge Hodges, for taking your time. Didn't have to. Again, the Supreme Court has discretionary jurisdiction. They don't have to hear it. So, the fact that they even heard it, that's indicative proof right there that there must be some validity to this argument in some form or fashion. So, again, you know, we're going to talk about they want to play license and play credential. Okay, well, there's me. You can verify those. Anybody can verify those, not just bar members. That's why bar members hate me, because I can do shit that they can't do. My emoluments are connected to the people. I know what a duty is. I just read it to you. Right here. Their duties are generally prescribed in such laws, the most usual of which are to attest deeds, agreements, and other instruments in order to give them authenticity. Verification purposes, right? Confirm something is true in the record, or something to protest if something is not true in the record. Okay, kind of give you an idea of where that is and where that comes from. Well, what do we know about law? Well, let's go back to those maxims of law. We know an unjust law is not law. So we're going to follow due process of law, and we're going to come in here and we're going to inform them that we know this. And how do we know this? We got right here in this matter, I've got two state court decisions that basically say standing is me versus this department, not the other way around. And the Florida Supreme Court saying, hey, we can't do anything until this guy down here has to make a decision. He's got to enter an opinion. Okay. Well, it's kind of hard for us to enter an opinion if you guys in DC haven't entered your opinion first, the first jurisdiction. Guess who else knows the difference between jurisdiction 1 and jurisdiction 2? Oh, that would be this guy right here. How do we know that? He's been doing business lawfully in commerce pretty much his entire career. So if he's willing to work with us, we're willing to work with him. Nothing wrong with that. We don't see anything wrong with what he's doing. And by the way, this is a pretty stout business plan. And yeah, I can see why he'd be a little more than slightly miffed about this. This is what's called a perpetuity. You know, starting at these negative nexus, these fake hearings, this shit made up based on this fake jurisdictional shit made up, stemming from this title shit made up, resulting in stipend payments, going back to these from any one of these 4 offices, are literally paying themselves to screw you, basically. And what does the Constitution's Amendment 13 say about that? Let's see here. This is not the exact interpretation, but this is pretty damn close based on what I've been able to locate so far. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, office or emolument of any kind whatever, from any emperor, king, prince, or foreign power. Such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. So, foreign power being something that is inconsistent with the ideology on which the Constitution was based. Christian Judaism, the Bible. So, that foreign power, right, being of Sharia in character and form, right, well, you want to know why the hell we have tyranny? There it is. Want to know why I haven't seen your dad in almost 11 years? There it is. They're selling justice for money and extorting this Sestake trust fund, right? Our retirement money through bonds, right? That's why I put bonds here at every one of these gains. Every time they take an action, they create a bond, right? So I don't give a damn if they file a notice of hearing. They get paid to do that. They pay themselves to do that. That's selling justice for money. That's treason. It's barratry, treason. So I called that shit made up. You can take that, send that right to Uranus. They like 5 pillars. I think Uranus being 5 planets away is justified and appropriate as far as we're to shove that shit show where the sun doesn't shine. So let's go on. Where am I basing this principle, this legislation? My intention here. Well, me being me, I said we're going to have fun with this. Necessity overcomes law, and it laughs at the fetters of laws. So I think it's safe to say even law has a sense of humor. So, especially when it comes to shit made up. Here's that ideology, that foreign power, that foreign ideology. I will begin by directing your attention to the 5-pillar construction of this title, A through E. I now point out the obvious conflict of this title not being Republican in character or form. I will further clarify it for you in breaking down each of the 5 pillars being consistent with this foreign ideology as follows. Political acts of domestic violence against women and children. VAWA, ASFA, Violence Against Women, Adoption and Safe Families Act. So, knowing and understanding what they're attempting to do through the implementation of this Agenda 20, whatever the fuck they call it now, excuse my French, Spanish, Italian, German, whatever the hell you want to call it, I don't care. So let's see here. Sent a copy of all of this stuff to the 133rd General Assembly for the state of Ohio. So they know I'm here. Gary couldn't do this job. He doesn't have standing to do that. Well, I know I sure as hell do. B clause is subject to mandatory oversight. So any action or motion that I take before the body, mandatory for them to hear that. So that's why I say they want to exploit their position of advantage, play Monopoly with me, with your dad. They want to play Monopoly Corporation with your dad. Yeah, that's not going to work out so well. Sorry. So, especially when my job was to maintain the truth in the record, and all I've been able to totally destroy is shit made up. This is going to be pretty ugly for some pretty bad actors pretty quick. This is basically the same motion that I sent to Lindsey Graham. So I just sent this to Speaker of the House in Ohio, and basically, he respectfully submitted this guy here as the CEO of me being in my official capacity right there. Okay, so you can read down through this. There's nothing disparaging of the judiciary, nothing disparaging of the Congress, nothing disparaging of the executive. I'm talking about impeaching the law. That law right there. This shit made up right there. That's what we're targeting. So, moving on here. That's the parliamentary inquiry. We went over that. Let's talk about this pyramid scheme. Ooh. This is from the state of Ohio itself. Of course, when I brought this before them, said, who gave you guys authority to create a pyramid scheme? It's acting outside the scope and authority of your emolument. Don't tell me you don't know this isn't a scheme, scam, and a fraud. I'm looking straight at a design of a pyramid right there. So that tells me that somebody knew this was a pyramid scheme when they constructed it, whether it was by happenstance or whether it was on purpose. And let's see here. I've been threatened with everything from prosecution by my former counsel here. All I did was ask her for a copy of my friggin' file, which was to include this guardian ad litem's report that says I'm supposed to have custody of you guys. Okay, so I have a cover page. Know when it was filed. You verify that right there, October 13th. At what, 9:50 something in the morning. 2009, October 13, 2009. Here, who was served a copy of that? These folks right here. So, again, it's one of the reasons I went to her to ask her for a copy of that document. She threatens me with the prosecutor? Get the hell out of here, you jackhole. So, how do we know that it's at least indicative that my claim is true and correct of that I'm supposed to be having custody of you kids? Well, let's look at this carefully and see what this says. Parties are legally separated and plaintiff Christina M. Hallett to provide health insurance for minor children. Plaintiff Christina Hallett to pay $442.91 per month plus poundage, blah, 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 blah. So wait a minute. If she's supposed to be paying, and we can definitively prove that this is shit made up, which I have done, effectively, might I add, you see where the problems are starting to happen here. Because as it turns out, the missing pages between the cover page and this back page, this supporting order, in this case, which is the only lawful case, because everything else that happened after this was deception, the fraud, the trickery. Oh, the dad and kids tried to overthrow the United States government is effectively what they're trying to say. That would be a disparagement and shit made up, according to the Constitution anyway, and I didn't write that. I know you kids didn't write that either. So, let's see here. It is further ordered, adjudged, and decreed that the clerk shall issue notices to all of these people. Okay. Well, again, I didn't get my notice. It was ordered that I was supposed to get a copy of it. Okay. Where is it? I didn't get that. I had to call, jump up and down, do cartwheels, flip-flop around, damn near threaten them with prosecutors before they would send me a copy of this. And, of course, knowing that the substance between here, this page, the title page, and this back page was hiding in the judge's private cabinet. Ooh, that would be that fraud, trickery, or deception, resulting in the injury of another member. I'm a member of that quorum. Well, now, somebody's got a problem, because what does that make the court? Why do I call it? Oh, yeah, a crime scene. Okay, so I say to this guy, Mr. Attorney General, you're supposed to go take care of that. This person's breaking the law. And of course, we get the typical runaround, go to the judiciary, hire another attorney, kick rocks, whatever. Yeah, okay. Mr. DeWine knew damn well of my monopoly challenge, wasn't happy about it. Do I care about that? No. He has a duty to perform under the terms and conditions of his emolument. Cited those, sent them to him. And he says, the Ohio Attorney General, a member of the executive branch of government, does not have jurisdiction to issue a warrant on Judge Rentala. Sorry, yes you do. That would be equal enforcement under the law. Co-equal branch of government. Any relief you seek must be obtained through the 11th Circuit. That's actually not true. That's not due process of law. This is bad legal advice from the Attorney General. You need to read the Constitution, Mike. The Constitution says my grievances go through the legislature. You are the actor in the second pillar, the executive, as you so astutely pointed out, that you do have jurisdiction over other actors under positions of emolument to provide oversight to the legislature. Is that act criminal or civil in nature? Withholding exculpatory evidence, I would call that under Brady violation criminal in nature, especially since we're talking over $10,000 now. That would make it a felony. So let's see here. Let's talk about this guidance document problem that kind of reared its ugly head while we were going through all this shit made up. Well, let's see here. I brought an example of one of those guidance document problems to the Congress through that judicial report. And immediately thereafter that, the Attorney General for the United States, Jeff Sessions, before Bill Barr, came out with these criteria. And I'll leave those up on the screen so you guys can read those for a little bit. Or you can hit pause and come back and read those in a minute. Basically, this is telling agency actors that any policy or guidance documents do not have the force or effect of law. Whoever the hell gave you that idea otherwise, that is shit made up. Well, of course, this is why they hide those policy and those guidance documents. You ever try to get one of those, even with a FOIA request? Shit. Might as well go to the dentist and try pulling teeth with no Novocaine. Good luck with that. But they're out there doing it every day. They're stating that their policy and their guidance documents have the force and effect of law. That's not Republican in character or form, even according to the United States Attorney General. Guy who's supposed to talk about the minimum standard. So what's next? Are we going to have the road department going to replace their brooms and shovels with AK-47s? I mean, that's in effect what they're talking about, because they're a department of the state. So, again, this became part of the process. So, now, what do we know? We talk about concepts of law. Talk about that barratry just for a second. Person is guilty of barratry who sells justice for money. That's exactly what Title IV is doing. Just showed it to you. A person is considered a possessor who has ceased possession through injury or fraud. That means I'm the possessor. I'm still the possessor because I showed you the injury and the fraud, both. It was all done because they're in a position of emolument, using that position as an advantage, right? Any advantage, profit, or gain. That's an act under, that's basically treachery. Deliberate and willful betrayal of trust and confidence. Basically, see confidence man, con man. Now, under the treason clause of the United States, technically speaking, the proper adjudication quorum is Congress. However, under treason felony, okay, this would be an act, a statute, or something else that would apply to them referencing treason that we could charge them with in a court. An act that shows intention of committing treason, unaccompanied by any further act to carry out that intention. Let me read that again. An act that shows intention of committing treason, unaccompanied by any further act to carry out that intention. Well, in other words, when they're selling justice for money, they know that we know that they're doing that. That is, in essence, an act of treason. They don't have to do anything else beyond that transaction to have literally committed an act of treason. Because even in accordance with their own standards of practice, right? Anybody who performs a task, who's ever done a job, you don't get paid before you do the job. You get paid when the job is done. To me, that seems pretty friggin' basic. But try telling that to the Bar Association. They think they're entitled to everything. But I think I digress as my head is about ready to explode. So, in light of that, I hope that kind of breaks this down a little bit better for you guys as to what I've done, how I've done it, why I've done it, you know, where E-clause fits in context, and how I've navigated this process working through Congress, right? Going in there and telling them, I don't give a damn what these actors under this, you know, proceeding under this foreign power are telling you. You don't have authority to alter the fundamental law. You've acted outside the scope and authority of the Constitution, the emoluments of your office. So, again, you're going to either be on the cleanup team, or you're gonna end up being covered up, one of the two. So, you know, going to need to pick it. And it looks like we've gotten some allies that we totally never expected would be allies. So that's a good thing. You know what that also shows? They were sick of being lied to as well. They were sick of being lied about as well. So on that note, I hope that kind of clears up some of the cobwebs for you kids. And I hope you guys enjoy doing the show, because I enjoy doing it. And, as usual, miss you guys. And, I know we've had our differences of opinion. And, but anyway, we'll have plenty of time to discuss this stuff later on. So I love you guys. I guess I will see you guys on the show.